We're going to be looking at the 5 Memphis police officers. The Memphis Police Association submitted a letter on behalf of all 5 of those officers talking about gross violations of their rights. We're going to be talking about that in this video. First, let's take a look at who the Memphis Police Association is. So we're going to go to their website. They have quite a bit of information here for you to determine what they do, who they are, who they represent. And as you can see here, here's their mission, to assure harmonious relations between the city and the association and to provide further equitable and peaceful adjustments of differences which may arise as related to wages, hours, and other conditions of employment. Who we are. Members are hardworking men and women, police officers who serve Memphis with respect and dignity. Who we represent over 2,000 commissioned police officers and retirees. They have some information here about their charitable foundation, some videos, gear, and more information. So you can definitely go to their website to see more about who they are. But now I want to jump into the actual letters that were sent so that we can take a look at those. And just so you know, before I open these up, I'm going to show you all 5 letters in one document. But just so you know, well, it helps if I click on the right thing. Let's get rid of that. It helps to just sort of know that they used pretty much the same document as a template for all 5 officers. Memphis Police Association, January 2023. As I stated before, I'm just going to scroll through so that you can see. This is the one for Emmitt Martin. Next, we have the one for Desmond Mills Jr. Then we have the one for Tadarrius Bean, followed by Demetrius Haley, and then finally Justin Smith. So those are all 5 of the documents. If by chance you downloaded the actual decertification package that the city of Memphis provided, you know that's about 104 pages. And if you're interested in just finding these documents, Emmitt Martin's on page 17, Desmond Mills, page 39, Tadarrius Bean, page 59, Demetrius Haley, page 80, and Justin Smith, page 99. I'm only going to go over this first one because, like I said before, they pretty much all have the same information in them anyway. To whom it may concern, the Memphis Police Association, MPA, objects to the Memphis Police Department's decision to proceed with the administrative hearing for Officer Emmitt Martin prior to the conclusion of the administrative investigation and or TBI's investigation. So basically, what they're starting off here with is, why don't you do the full investigation? Why don't you wait until all of the information is in before you start this administrative hearing against the officer? Next, it goes to the policies that it's actually using for this. It says, per Article 14, MOU, Memorandum of Understanding between the MPA and the City of Memphis, a reasonable amount of time to review the statement of charges, including all proof to be relied upon by the hearing officer, is to be given to the representative prior to the administrative hearing. Upon review, several pieces of proof were either omitted from the file or incomplete at this time. Body-worn camera video, which was referenced multiple times in the statement of charges, was not provided to the MPA representative, nor were statements from other principal and witness officers. These are only a few examples of the gross violations of this officer's right to due process. I want to talk about this a little bit more because there's some information in here that I included in another video that I think might be part of what they're talking about. First of all, they're saying several pieces of proof were omitted or incomplete. So they're saying they haven't gotten all of the body-worn camera video. Now we know that some of that video is available on the City of Memphis's Vimeo site, and they have made that public. But that's likely not all of it, or they're saying they haven't received all of it. was not provided to the MPA representative. And then it says, nor were statements from other principal and witness officers. So there are these other people who may have made statements that they haven't even seen. So remember, early on, they kept saying, we're still investigating this. We're still looking at other officers who may have information about what happened here or may have participated in some capacity. Maybe not because they were on scene at the site, but through other conversations. We haven't had all of that come out in the public yet. And it sounds like they're saying, we heard you make those statements too, but we haven't gotten those information. The Memphis Police Association is using this as their examples. They say these are only a few examples of the gross violations of this officer's right to due process. So that's sort of what they're saying here. Give us all of the information. Let us have a chance to make, to at least represent our person or our officer with all the information that they need. All right, the next part, let me keep going here and see what else they say about this. Not only is this a right under the MOU, but it is a right guaranteed by federal law. See Cleveland Board of Education v. Loudermill. They've got the case there where the court provided that a public employee with a property right to his or her employment must be provided notice of charges against them and a hearing to provide them with an opportunity to defend themselves against the charges against them. Additionally, that hearing must be a meaningful one. And it says in Wagner, the case that it cites, which was actually in against the city of Memphis, Mayor Henrington predetermined the outcome of the hearing, and the court said there was no due process. Okay, so they have this statement in here, which is very interesting for me because they don't go into any detail about it. If you're really, and this is just me talking as an attorney, I'm not just going to put that case in there and let it stand on its own. They basically have this, let me click back over so you can see me pointing to things. So they've actually put this case in here and they say that additionally, this hearing must be a meaningful one. They're not connecting the dots here. Okay, so that means go to the actual case that you're talking about. Find the part in that case where they say you neglected to provide all of the evidence. You neglected to provide other statements, names of witnesses, information like dates where things occurred, places where things occurred. You would connect the dots to say as to why you don't think now is the time to have the hearing. Let us get all of the information and let you give it all to us in a reasonable time so that we have a chance to review it. They just put this statement in here. And the reason I'm talking about this is not for me to sort of give support to these Memphis police officers. The reason I'm talking about this is for you to think about this when you have an attorney representing you. And they say, well, I'm going to put some information in here about this case because I think this case is helpful, but they don't connect the dots for the party who is going to be getting this letter, then it doesn't come across with very strong support for the argument that you're trying to make. Ordinarily, you want to say, here's the rule, and this is typically what law students learn. It's called the IRAC method. The issue is whether or not they met the requirements of the MOU, of federal law, of their civil rights, okay, by not waiting until after that hearing had been concluded, not making sure that they had received all of the evidence, all those things. Those are the issues. Well, then you say, well, here's the rule, and you point to this case. In this case, that's all the association did. They said, here's the issue, here's the rule. You want to provide analysis. You want to lay this out and say, here's what that court said. Therefore, this is why you got it wrong. This is why it was wrong for you to proceed. And so the reason I'm really talking about this is to help you provide an overview of if you're hiring an attorney to represent you, or if you're in a space where your union representative, not just a police union, any workers union, your union representative is putting forward a statement in support of you, make sure they connect those dots for you. Don't think that just because you cite some law or some case that is enough. Make sure your representative is laying out all the facts, showing how it's all relevant, and then saying at the very end, that's why what you've done here does not meet the law. So I just wanted to use this particular letter, not so much as something to support these officers, but something to help you understand what your representation should look like if you are a worker anywhere, a worker for any company, a worker in any industry who maybe has someone who's going to be submitting a document saying, hey, my due process rights were violated or something to that extent. So I hope this information helps you out, not just with understanding how this works in this case, but how this works for workers generally when we're talking about employment law. So go ahead and give the video a thumbs up if that provided you with some information. I think that was everything I had on my list. And don't forget to subscribe. Peace.